What's up, everybody? Supreme Decisions here, and today I want to talk to you about the ability to call an attorney to the stand. This is something that I used as a strategy for my RICO case, and this is something that you can also employ under certain conditions. Now, the ability to call an attorney to the stand as a witness is generally limited in most legal jurisdictions due to ethical concerns about a lawyer's potentially having to testify about confidential client information or potentially creating a conflict of interest with their client's case. However, in rare situations, a lawyer may be called to testify if their testimony is deemed absolutely necessary and there are no other viable options. Now, the reason why I brought this up is because it's something I saw employed in another case, but it was also, like I said, used as part of my strategy because the prosecutor in my RICO case, he had gone on to several news conferences and things of that nature, and he spoke about with definity about alleged crimes that I had committed and my brothers had committed and all this good stuff without actual proof of these crimes. There are exceptions. Other than the ethical issues, there are also potential conflicts of interest. Now, here's where the exceptions lie. One is limited knowledge. If a lawyer only has limited knowledge about a specific factual matter that is not directly to the client's legal representation, they may be called to testify. In this context, he did not have any, direct issue because the client was the government versus myself and my brothers, so he could testify. Adverse witness. In some situation, an opposing party may attempt to call the opposing counsel to the stand to try to elicit unfavorable testimony. Now, that was actually my strategy. Call him to the stand in order to elicit why the actual charges were being brought up because of the statements he had made outside of court on TV in front of a national audience. So I was going to use that, however, it didn't happen, as well as it also put him in a bind to where I didn't have to kind of go against him the entire trial. They used other litigators that were less experienced than him to go against myself, which also aided in my strategy. And the last will be a court order. Now, a judge may order a lawyer to testify in exceptional circumstances, usually after carefully consideration of the ethical implications. Now, when we're talking about this, the one thing that we are discussing is the fact that the judge is saying, yes, they can. And in my case, it was a judge's order as well because I used subpoena power. I actually subpoenaed the opposing litigator in order to call him to the stand because of the statements that were made outside of court to a national audience. So always understand you have that option in certain instances in which you can also employ as a strategy if necessary.